accordance with Section 92-5A1 Hawaii Revised Statutes, and/or to consult with the Commission's attorney on questions and issues pertaining to the Commission's powers, duties, privileges, immunities, and liabilities in accordance with Section 92-5A4 Hawaii Revised Statutes. So nice to see everybody sitting at the table, but I do need to take roll. So commissioners, if you don't mind, I'm going to start off with Commissioner Abe.
Here.
Commissioner Andrews, who is excused. Commissioner Emery.
Here.
Commissioner Kyono.
Here.
Commissioner LaCosta.
Here.
Commissioner Love.
Here.
Commissioner Center. Okay, the time now is 9:04. We have quorum. The public was noticed, and I call this meeting to order. Starting off with the chair's report. Just a quick mention, we are first time doing this, being recorded on screen, so if everybody can just bear with us. Sometimes first time going through it, we run into a few bumps and bruises, but we'll get through this with everybody's cooperation, okay? Moving on to executive officers report. Miles?
The Commission shall afford all interested persons an opportunity to submit data, views, or arguments in writing on any agenda item, and shall provide all interested parties an opportunity to present oral testimony on any agenda item, subject to the conditions set forth in Section 16-99-83 Hawaii Administrative Rules. The Commission may remove any person or persons who willfully disrupt the meeting to prevent and compromise the conduct of the meeting in accordance with Section 92-3 Hawaii Revised Statutes. There are no additional distributions, and the next agenda item requires a motion, Mr. Chair.
Commissioners, you had an opportunity to review the minutes. Any questions, concerns? If not, may I have a motion, please?
Motion to accept minutes as distributed.
Thank you.
Second.
Thank you. It's been moved by Commissioner Acosta, seconded by Commissioner Kyono to accept the minutes of the meeting. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not seeing or hearing any, motion passes. You can pass your vote. Thank you very much. We are moving on to item number 4, committees and program of work. 4A, laws and rules review committee. 4A1, legislative and government participation report. 4A1A, House Concurrent Resolution 102, strongly urging the Real Estate Commission to allow for the administration of the real estate salesperson's examination in the Japanese language for purposes of issuing a limited real estate salesperson's license for the sale, of timeshare products in Hawaii to Japanese national visitors for the purpose of enhancing Japan's involvement in and support of the Hawaii tourism industry. So commissioners, you all had an opportunity to review this. This is FYI, I believe. Anyone have any questions or concerns on 4A1A?
Didn't the commission already discuss this at length and vote on it?
Yes, the Commission addressed this at the August 23rd, 2024 Commission meeting. And the Commission voted no to the request.
That's correct. So why is it on the agenda again?
They persuaded the legislature to issue a resolution strongly urging the Commission to consider offering the real estate examination in the Japanese language. So it's just a concurrent resolution coming down from the legislature.
Unless the commission wants to restore it and bring it back up, it's just a matter
It's
of,
just strongly urging the commission, but it's still the commission's decision whether or not to, consider this or not.
So if you want to move it to exec session to discuss further, we could if you want to.
I'm just trying to get the lay of the land because I thought it was over, but they're asking us, as I see it, to reconsider it. And for us to reconsider it means the commission is going to have to bring it back up on the table for discussion and decide something differently. We don't have to do anything, I don't think.
Right. Or you could probably move to not accept this, if I'm not mistaken, but
Or if we make no motion, then it's just standing on our prior decision, right?
Or if you wanted to extinguish the issue, then you could just make a motion to instruct staff to provide the commission's testimony opposition.
But is that necessary? Because I thought we've had conclusion on this.
Or maybe you guys can make a motion to reaffirm your previous decision. Because this is the
something
next, this was
that
something.
requires a motion? No, right?
No?
Okay, so if we say nothing, it's status quo.
Well, what happened was after that August 2024 meeting, the resolution came up. So now, if you guys want to reaffirm your stance on the previous discussion that was previous to this resolution, then that would be great.
But if we don't do it, I guess I'm asking if we don't do anything, where does it stand? What happens?
They're asking the commission, they're urging the commission to take a look at and provide the examination in the Japanese language. So it stands as if the commission didn't do anything after the resolution.
Okay,
I'm
so
okay with making a
we
motion
have to reaffirm our position?
Yeah,
Let's say, yeah.
I'm okay with making a motion to affirm our decision to deny the request for offering the testing in Japanese language. If everybody feels that's kind of where we want to go.
I will entertain all motions, so yeah, I can.
Okay.
I will second that.
Well, I haven't made the motion, I'm kind of trying to
Oh,
get a
I'm
lay.
seeing some.
Trying to get a lay of the land.
Sounded like a
Anybody-
motion.
I know it did. Are we going to have discussion first then?
Sounded
Well, I
like
make a motion to affirm our prior decision to not offer the real estate exam in the Japanese language for reasons previously discussed.
I'll second that.
It's been moved by Commissioner Emery, seconded by Commissioner Abe to affirm the decision that the commission made in a prior meeting to not entertain a Japanese exam for licenses. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you very much. Next item for B, Condominium Review Committee, 4B1. This is a case law review. 4B1A, United States versus Kailua Village Condominium Association. This, I believe, is an FYI, but we will, as commissioners need staff to quickly go over it. No? All good? Okay. Very good. I trust your judgment. Moving on to item 4B2, rulemaking. Chapters 109, 119, report permitted interaction group on recommended revisions to Commission's proposed condo rules, simultaneous repeal of Hawaii Administrative Rules, Chapter 16-107, and adoption of Chapter 16-119.1 through 16-119.8 relating to condominiums. This one, I am going to ask staff, specialists, if Keaton could just quickly address all of you. So Keelan, go ahead.
Thank you, Chair, and good morning, Commissioners. Just a brief recap at the December 18, 2024 meeting, Commission established a permitted interaction group tasked with, one, conducting a review of its proposed draft condo admin rules, including testimony received for the draft rules at the November 29, 2024 public hearing, and two, proposing recommended revisions to the draft rules. Commissioners Andrews, Emery, Love, and Vice Chair Center were appointed to the PI group. The group fully considered all the received testimony respecting the Commission's proposed rulemaking actions. After review and discussion of the draft rules and testimony, the group presents its revised draft of the proposed condo and admin rules. We prepared two files attached, and just one to show the changes that were made to the first draft, and things like kind of illustrating the revisions and describes the justification for each revision. And then another package, which is a clean, post-processed one of what the admin rules would look like after the revisions. Also included for reference are the 3 written testimonies received for the draft rules. The group adopted most, if not all, of the language revisions that were requested in the testimony received. Testifiers' justification for the revisions are also included in that revisions and comments file. Just as an FYI, because this is a report by a PI group, there is a law, HRS 92-2.5 B1C, which provides that the commissions or any licensing authorities deliberation and decision-making on a PI group's report, so for this matter, the condo draft rules, has to occur at a subsequent meeting and not this meeting. So this is more of an FYI. Actually, it is an FYI. So as such, this will be placed on the Commission's June 27, 2025 meeting agenda for the Commission's appropriate discussion and disposition. And shortly after this meeting, we will upload the PI group's revised draft of the Commission's proposed rules onto the DCCA-PVL and REB websites for a public review and download.
Thank you very
When
much.
can it be formally adopted?
Formally adopted, timeline-wise, as in routed and approved by the governor?
Approximately, because, in the condo world, right now, there are attorneys out there who say the original administrative rules were under 514A. 514A was repealed, so they're not valid, even though we have opinions saying they are still valid, except where they contradict 514A. I think the industry deserves to have this put to bed, and we know, because there's a lot of discussion about reserves. And I think these new rules, which include all the subsequent new laws that were passed, would be valuable to anybody trying to analyze or look at this. So I guess my question is, how long is it going to take?
Well, if I can recall the rulemaking process. So let's say that the commission does, at the next June meeting, approve the PI group's second draft of the rules as the commission's proposed rules. Then we'll have to schedule a meeting. Well, actually, it has to be reviewed by the commission's deputy attorney general to determine whether or not the changes are substantive to warrant restarting the process at a certain period, whether or not it's reviewed by LRB or whomever, or another public hearing is required. But let's just entertain that maybe it's not required, a public hearing is not required. The rules would have to be reviewed by the Small Business Regulatory Review Board. So schedule it for their agenda, present at their meeting, just to provide a summary. They're okay with it, then it goes to Budget and Finance, and then enrolled to the governor for approval. Hopefully I'm not missing an agency there. So if anything, best case scenario would be before the end of the year, the rules could be promulgated.
Now I understand the process.
There's a lot of agencies, yes.
So the end of this year, if I heard you correctly.
Yes, yes.
Commissioner Acosta?
Thank you, Chair. So is this the final draft, or will there be another one?
This is the current final draft.
The reason I'm asking is, there is so much paper here, it would make sense that we just bring this back next month instead of having many more trees die.
Yes. Yes, I did feel bad for the trees. And then I also, when I decided to make 2 versions to illustrate the changes, I felt extra bad.
I appreciate that. They appreciate that, I'm sure.
Commissioner Center?
So if the RAG deems it non-substantive changes, then as it goes through the review processes at the various agencies, should it, practically it should be faster because they're only reviewing the highlighted changes that you redlined? Or does it require an entire review where they relook at the other provisions that were already submitted when we were going through the first round?
Well, the Small Business Regulatory Review Board, SBIR, they've already reviewed the rules. And part of the rule process is we schedule it for their hearing, then hold the public hearing, and report back of any changes. And so we explain the changes. The agencies generally would just review the rules as a whole new rule package. So this would be the final. And if there's no changes, this would be the final. It's also enrolled with the government.
Okay, so small business should technically be faster because we were already in the cache for that already, right? Because they reviewed the rules and now they're gonna just review changes, but the other agencies haven't reviewed the whole rule packet. Or is that what, am I missing something?
I think Budget and Finance actually did review the rules with small business prior to the public hearing as well, if I'm recalling correctly. So they're just reviewing the updated draft.
Okay.
And then at the small businesses meeting, I'll report that the testimony received and the changes that were adopted into the draft to accommodate the concerns and address the concerns.
Yeah.
I believe that's what SBIR's primarily focused on.
Yeah, I guess the thing I'm focusing on is to encourage the agencies who have reviewed the rules, the summary, doing a summary of what exactly changed and the red line, I think will encourage them to get it through the process faster.
Oh, yes, they're actually the ones emailing me on what's the status, so.
Okay, good. Okay. Yeah, because I know the delay was actually, the commission reconsidering and relooking at it, and it's not on staff's part or staff's fault for not facilitating this to get it through. So I just want to make sure that we didn't lose you too much time.
Oh, no. Yeah.
Okay.
Yeah,
We seem to be on track to, that if best case scenario, these rules are promulgated before the end of the year.
Yeah, I would just say I agree that we need to get it done. The original draft was 10 years old, the administrative rules. In the last 10 years, there were several changes to the law that the draft rules were in contradiction to the current law. And that's the basic changes the PIG committee made to bring it concurrent to what the current law is. But it's just something we want to get done by the end of the year if possible and give it a sense of urgency, is all I can say.
Commissioner Abe?
Yes, so if we do approve it on June 27th, could you keep us updated of the status of this when each committee approves it? Could you update us throughout the meeting so we kind of have an idea what's going on?
Okay.
If that's
I
possible.
can include a memo for each commission meeting agenda moving forward until those rules are promulgated.
Yeah, 'cause I think that's really important, yeah.
Okay.
Yeah, so first off, I just want to thank Commissioner Andrews, who's not here, Commissioner Emery, Commissioner Love, Vice Chair Center, on sitting and helping with this, because I know it's a monumental task, but long overdue. So thank you very much for your wisdom, your assistance, and everything on getting this done. We will take Commissioner Acosta's wish to save some trees and bring the same document back as to not to waste anything for the next meeting. And I think Keaton's gonna help Commissioner Abe keep this on track by giving her updates throughout the process. But so if I heard you correctly, for today, it's just an FYI, but when we meet on June 27th, we will be requiring a motion to, I think, approve the members and approve the delegation to go to
The motion would be for the rules to move forward.
move forward, correct, okay. Okay, anybody else? Any other commissioners have any questions for this item, agenda item? Good work, thank you very much. Moving to the next item. We are now on agenda item 4B, 3A. Condominium governance and management. 3A, ad hoc committee on condo affairs and solutions. Staff, let me see. Keaton, you want to speak on this one, or?
Yes, sir.
Okay, go ahead.
At the last commission meeting, the commission moved to establish an ad hoc committee on condominium affairs and solutions. Primary task is to assist the Hawaii State Legislature and other appropriate parties by discussing issues and identifying solutions concerning condominiums. Real estate branch staff subsequently sought and considered potential members who collectively will make the committee have a broad range of knowledge about condominiums and their related issues. And so accordingly, we're requesting for the commission's approval, one, for the following members to serve on the committee, and I'll go over the members shortly, and two, for future changes to the membership of the committee to be delegated to a supervising executive officer. So right now, committee composition would be Commissioner Abe as committee chairperson, and then branch staff, Neil, myself, Dathan, and Lori. And then the committee members, we have Bill Owens, he's the board president of Parkview Waikiki Condominium. Jeff Cedino, he's the board treasurer of Ode Rancho Condominium. Jonathan Billings, he's the founder and president of Vertical Hawaii Home Inspections and Reserve Studies LLC. Nalan, she's attorney and director of Game & Key. Leon Kupchak Hastert, and Sachin Shah, he's the VP of Engineering and Design Build for Dorvin D. Lays Co. Inc. And he's also the board member of Haleokalani Towers Condominium. I just wanted to note that while these members do not have background or come from all the wide range of aspects that involve condominium governance, it's the understanding that this committee has the ability to request the attendance and discuss certain subject matter things with subject matter experts to better understand the nuances of certain issues. For example, if there was an insurance issue, then the committee could request someone from the insurance side to come and speak with them to learn more about the insurance issue. Or even if it was a reserves issue that Jonathan Billings, who's familiar with reserves, is unfamiliar with, then you could actually request for Commissioner Emery in his reserve capacity to speak more on certain stuff.
Thank you. Commissioner Emery?
Going back a little bit to the formation of this committee, I think it was 2023, the legislature established two task forces, one for homeowner association and one for condominium associations. And that task force was provided specific issues to get involved in or give a report on. In that process, it was the group was a broad group in the sense they were different people with different views and agendas, whatever you want to call it. In that process, they came back to the commission and they said, we want to refer this and get information from the Legislative Reference Bureau and what other districts are doing, and we want 350,000 of the budget, of which they were going to get 150 or 175,000 from our education fund, which I'll remind the commissioners, the majority voted against that, but then the legislature, with its power, took the money anyway and did it. So there's already a committee established of volunteers who are committing time over the last 2 years dealing with condo issues. How does this not take away from all their hard work, number one? And number two, add something different that's already been established by the legislature by having a task force?
That is correct. So these task forces are DCCA task forces rather than a committee for the commission. And so the committee will be assisting the commission, whereas these task forces, they also have a sunset date. So they have to provide a report to the legislature and stuff. This committee is more primarily to assist the commission with discussing and generally discussing and solutions that come up and arise. And yes, there is task forces, and they did refer it to an LRB study, and the commission can review the LRB study, but this committee is for the commission as well.
But wouldn't it make sense for this, quote, new committee to have the benefit of the LRB report and the other report of what was discovered after 2 years of work and $350,000 of money? Wouldn't it make sense? Because I know most of the people who you proposed on the committee, and they're very nice people, but to say they're deep in condo management issues, they may have little pockets of information, but they really aren't in depth, really engaged. If you look at the history of the legislature and testimony and committee participation as an industry, they're really not heavily engaged in it. But so my point is, why are we pushing this forward before we have the LRB report and the task force report? Because even this committee would benefit by having that information available to them and what other jurisdictions and other people are doing. So I wasn't here at the last meeting. I apologize. I was traveling, but I would have been recommending we postpone that until the LRB. The LRB report is due in 2026 before the legislative session. What I would have said, let's postpone that until the task force report and the LRB report are finalized. And then we need to have, I think, not a shotgun approach with the commission. We're going to deal with whatever problems are in condos. That's a really wide open territory, and so I would have preferred that we, frankly, we got the LRB report and the task force report before we, I'm not against the future committee, I just think the timing is not best, if we don't have the information that's going to be helpful to people. And so I would be, I'm thinking out loud, by the way, so I'm not making this motion, but I'd be deferring appointment of the committee members until 2026 after these reports are issued. So we knew more what we're dealing with. I'm not even sure the commission has authority over some of this stuff.
It's a good point. Well taken.
That actually was brought up at the last meeting as well. That if this committee were to be formed, and caution that if the committee were to provide a recommendation, that it shouldn't be counter to the legislature's mandate of Act 164. I hope I get the year right, SOH 2004, for the condominium principle of self-governance, and so they have to abide by that.
Well, I clearly understand from condo owners' points of view, some of them, on the stress history has made on special assessments and reserves and argument who's at fault for that, and that leads into governance and directors of elections and things along that line. But I'm not sure, from my own personal observation, it really accurately describes the issues. Unless you're really engaged in this, you're not going to understand all the finite nature of this. Think of it this way. In 1995 approximately, don't hold me to the exact date, the legislature passed a law requiring all condos to be 50% funded by January 1, 2000. Well, we're 25 years past that date, January 1, 2000, and we're arguing about condominiums being underfunded reserves. Well, Is there any logic to, we said you only have to be 50% funded, why did it be short 25 years later and for all the money you need for the painting? I mean, you set the bar so low, even though the semantics they use are not technically correct on a national level. But in some ways, it can be anticipated you're going to have some of these problems. And so what do you do when you have a building that has $17 million in repairs, their pipes are not working, and here we are in 2025, I don't think the legislature is going to give them the money to fix it. It's going to be a problem. So I would just like to see these issues addressed more fully, and whether it's up to the commission or not. I can tell you now the industry is working on several seminars on reserves that are much more in detail for lawyers and others to take the history of this and where the problem really lies with regard to reserves. I'm just fearful that taking some volunteers who care, who don't have the experience, and putting them overlapping in the task force of the legislature, then you get a competing different points of views. I'm not sure it's going to be helpful to us. And so my preference is to defer appointment of members of this until after the LRB report and the task force report are issued in 2026.
Yeah, I totally respect what you're saying, Richard. But I also work with a lot of condos too, and there's a lot of unheard owners, you know, and their concerns. And I'm thankful for the new reserve study requirement, independent reserve study. And what I've seen, a lot of condo associations trying to follow it to get their unfunded balances lower so that they have more funding. A lot of them are bordering 30% funded. So they're trying to get it up to 50 at least, you know, next 3 to 5 years, which means raising maintenance fees. But I think a lot of communication too with the owners are not there. And my understanding of this, actually, I was kind of excited because I thought it would be more a preliminary gathering of information. And after going to the Senate hearing with Chair Jarrett and Carol Fukunaga, it seems like they have a lot of concerns still and unanswered questions. And they may have a lot of public input that I've never seen either, but from what I've seen is it might be a good start anyway. And if it goes nowhere, then, you know, we'll see. But I feel there's a real desperate need from a lot of associations. Well, because they're over 50 years old, they're underfunded. Some people have to sell their homes, maybe they can't be assessed a huge amount. But let me just hear what because I'm for the owners and board members too, who volunteer their precious time, that they get the right consultants. And how do we coordinate all this, you know, to assist them, you know, with these kinds of challenges. And I know there's, you know, other things to consider, but I thought it would be a more preliminary.
Well, let me just say one thing.
For now.
And I won't say any more because I don't want to make this a big issue today.
Yeah.
Certainly education for the board members and management companies, everybody's important. People don't realize that there's two types of reserve studies. Each one has a different funding plan. One uses percent funded, one uses cash flow. They're very different. Yeah. Believe it or not, a condominium using national standards for calculation that is 40% funded will have all the money they ever need to take care of the project. Because you don't understand, most people don't understand what percent funded is. And when the legislature adopted this, if you read the prior testimony, they didn't understand what percent funded is based on what national standard says it is. And so then you get the cash flow. And so I'm of the belief, as I was saying to one of the commissioners earlier today privately, is that number one, certainly education of board members and management companies of what this really means is important, and how they're going to address it, you know, is important. But number two, they need to understand what this data really means, because we're making decisions based on false assumptions of what the data means. And so you'll never get to be 50% funded without overfunding the reserves. You know, unless you want to violate national standards and how national standards says this is calculated, you know.
I think a lot of it is, you know, we can anticipate inflation, things like that, or, you know, prices of repairs are going up, labor, materials. So the better funding you have, the less chance of being assessed, special assessments for owners. So I kind of feel that, granted, sometimes 40, 50% might be enough, but at least it relieves the pressure that you won't have to do a special assessment if you find out later elevators double in price or something like that. So,
I've
So
always
it's something
argued
to-
that the commission should do in its biannual registration a supplemental report to gather data. Because the two most important components from a practitioner are, number one, how much money are you putting in reserves? What percent of the maintenance fees is it? I can give you statistics on that, but if they're not putting enough money in reserves, they're never going to be properly funded, no matter how they skew the reserve study. The second is the current condition of the fund balance. How much money do they have? Do they have enough money for the next 5 years of components? The reserve study, changing all those rules around is not going to help the problem. They need to focus on a different level of education and a different standards to measure against versus trying to take a.
no, I think it's a good guideline, though. It's once every 3 years, this independent reserve study, because prior to that, a lot of associations weren't even doing decent reserve studies. So
Yeah, so, what I'm seeing right now, I think is really good. Both of you are very passionate on both of your sides. Before I kind of make a comment, any other commissioners have any?
I just want to say one thing about the 3-year review.
This is off
They
topic.
can't find people to do it because you're asking a reserve expert to take someone else's data, their cost replacements, their estimates and everything else, and the liability associated with that is great. It's very difficult, the way that is written, to get reserve practitioners to agree to do a review.
This is all very important, but it's off topic. It's not relevant to the agenda item, which is the ad hoc committee. And if I may, the ad hoc the commission already has an ad hoc committee on education for real estate issues, and the ad hoc committee assists the commission in developing core courses, pre-licensed education, curriculum and things like that. This was intended to kind of model that type of support to the commission to address issues that may come up. It may involve reserves or it may involve governance, whatever. But whatever the issue that arises, I believe this ad hoc committee was comprised to obtain information. If they need to get information from subject matter experts, then those appropriate individuals will be invited to provide data and information, and then report back to the commission any recommendations that we have, and the commission can consider those recommendations from the ad hoc committee. But I believe that was my understanding of what the role of this committee was. But not necessarily to mirror anything that the legislature was doing with the Legislative Reference Bureau and these task forces, but to serve as a advisory committee for issues that the commission identifies as relevant to condominiums. So,
Yeah, no, both of you, there's no right or wrong answer. Clearly, both of you are trying to do something to benefit the public, which is what we're here for. And I think, if I'm hearing Commissioner Emery correctly, yes, we want to be efficient. We don't want to waste unnecessary time and whatnot. So he does have a point. At the same time, I think we do need to really understand what the public's asking for, what problems we should address. Obviously, there's too many to address, but I think if Commissioner Abe can basically compress the problems, prioritize it from one to whatever they can handle, and then we get additional results like what Commissioner Emery is saying, then maybe those gives the answers immediately to get rid of some of these problems, and I think we got both of you happy, win-win moving forward. So folks are both doing a good job, so I think we should take both into account. But getting back to the fact of what Miles said, what's in front of us on the agenda is basically this ad hoc committee, which supposedly is more to help us as specialists, Kleinon said. So again, everybody has good points, but let's just address this right now. I do need a motion on this, okay? Yes, I believe it's two. approve the members, I think. And also, I think the last statement is something about delegation to supervising executive officers at you or to you? Okay, so the motion, if we could do a motion to actually cover approving the members and the delegation to Neil, that would solve it in one motion, if you so.
I move to approve the members as stated on the memorandum and to delegate to the supervising executive officer items that need to be done.
Second.
Okay, it's been moved by Commissioner Acosta, seconded by Commissioner Kyono to approve the members listed on the memo dated May 21st, 2025, and to then also make all changes, be the delegation, or the delegation goes to supervising executive officer Neil Fujitani. Commissioners, all those in favor say aye.
Aye.
Any opposed?
I abstain.
Any abstentions? We have one abstention. Commissioner Emery, remainder is aye. Motion passes. Thank you very much. Moving on to item 4B, 3B, mediation and arbitration, approval to enter into mediation contracts. This one does need a motion, but prior to that, I'm going to ask Condo Specialist Choi to address the commission members.
So, the Commission runs a number of alternative dispute resolution programs, mostly arbitration, evaluative mediation, and facilitative mediation. They're expiring soon, so we do need a motion to enter into additional contracts going forward, so we can offer subset mediation to various condo owners with registered associations. Typically have about 59 to 60 every year, right, roughly, Tammy? But again, we do need a motion to enter into an additional round of contracts to keep the resolution going.
I did check with staff earlier, so the people that they do have still doing a good job, so no complaints. But we do need a motion because the time frame, the deadline is nearing and we need to extend it.
I move to approve the
I just have
contract.
a couple of questions, please. Is there a budget for this? And also, what is the criteria to be accepted for mediation? Is there a criteria list? And then what is the budget for this?
Each one is about 20,000 per provider, and the total budget is 4.
So it's 20,000 for facilitative in total, and 200,000 for evaluative in total. So all it's on a first come, first serve, once they submit their invoices.
And that's funded through the biannual registration fees. There's a specific amount of money just for that. As for the criteria, I think they have a history of providing mediations. Generally well done. Not every mediation is going to be successful. There's somewhat of a notion that everyone's a rational actor, and that's not necessarily true. So you're not always going to get perfect mediations. But for the most part, these mediators do provide a pretty good job. I think we're roughly around, off the top of my head, 60% they come to mediation agreement, or either before or after or during. But yeah, some of them do more than others. Like our Big Island one only gets a handful a year. I think there's just not that many condos out there, where the Oahu ones have substantially more of mediations. And based on what they provide sent to us, they do a relatively good job at least getting the parties to the table to talk about their issues.
Okay, thank you.
If you look at DCCA files every year with the legislature, a report. If you look at last year's report and the one prior to that, it's been pretty consistent. There were about 53 mediations a year. 2 or 3 drop out because the parties agree to a solution. So they probably said, we don't want to spend legal fees or whatever, and they figured it out. Of the remaining, let's call them 50, about half of them are resolved through mediation. About half of them are not resolved through mediation. Of those not resolved, I tracked this, by the way, none have resulted in litigation where it could be they just have too much pride. They don't want to agree that whether they're right or wrong or whatever. But when you look at this 168,000 units, 2,000 condominiums, It's not a huge number, but it is a very valuable option for owners and/or board members to try to bring resolution at the most economical way and friendly way through this. So I
Yes,
support.
thank you for all that, because, that's what, I tried to shorten it with saying, I checked and it's all good, but
Yeah,
you're
yeah.
just backing up what I'm saying, so thank you, Commissioner Emery. But yes, I checked with staff, so far, they're all doing well, and so, yes. Anybody else? If not, if I can have a
I
motion?
move to, or you move to approve?
Richard made
I'll
the
second.
Well, I don't care, I'm first, I made a motion to approve the mediation contracts, and if you'd rather do it, that's okay with me.
No, you did it already.
Yes, the
You
motion.
can move it and you
And
can
I'll
second
second
it.
it,
yeah.
So it's been moved by Commissioner Emery, seconded by Commissioner Abe to approve the contract, to extend these contracts. Commissioners, all those in favor, say aye.
Aye.
Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you very much. Okay, next item on the agenda is item 4C, Education Review Committee. 4C1, Continuing Education Administration, Curriculum Courses Provided Instructors. 4C1A, Administrative Issues, Continuing Ed Providers. You have a list in front of you, Commissioners, for those two courses. Any questions, any concerns? Hang on. Is that because somebody's here? No, this is a rep. Okay. So I just need a motion to approve these two courses.
Move to approve courses as stated.
Thank you. It's been moved by Commissioner Acosta, seconded by Commissioner Kyono to approve your continuing ed providers and courses ratification list dated May 30th, 2025. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Thank you very much. Moving on to the next item, 4C1B, Continuing Education Core Course. We have the second draft of Core A 2025 to 2026. The title is Advertising, Agency, and Accountability. It's your Kuleana. I believe, Mr. Kaneshiro is in the audience to answer any questions that commissioners may have. So, staff, you want to address it first?
Everything go ahead. This is draft number 2, as stated, and Everett is here. He's a course developer, writer, and he's here to answer any questions the commission may have.
Commissioners, do you have any questions for Mr. Kaneshige? Yep, let him take a seat first. I like his shirt, related to mine, but I can still make a fair and honest decision. Go ahead, Commissioner Acosta.
Thank you, Chair. Good morning, Mr. Kaneshiro. Thank you for being here this morning. Excellent course. Thank you so much. It's very, very much needed. I find that some people, and you know much more than I because you're the educator, that they learn by visual aspects. So when I was looking through this, I didn't see any like signs that say right or wrong or yes or no, because I pass signs every day that are wrong, which makes me crazy. So perhaps some examples might help rather than just people reading. If they actually see what is right and what is wrong, that might assist with the education. That's all. Thank you so much.
Chair, may I respond?
Sure.
Yeah. So for the record, aloha, good morning, commissioners and staff. My name is Everett Kaneshige. I am the consultant working with the commission and staff to develop the 2025 4A class. Commissioner Acosta, with respect to your comment, excellent comment, and that's been my experience. You can put one of the requirements for the core course is that we have a comprehensive manual containing all of the information, as well as the legislation that is passed every year. But my experience in the 10+ years that I've been doing this, you're absolutely right. The way that the licensees really get it is to go through the process of seeing and discussing these issues. And so what we also have besides the manual is a PowerPoint presentation, and I've done that every year. And I try to make that as visual as possible. So for example, as you mentioned, having pictures of a sign that's compliant versus a picture of a sign that's not compliant. Having just a picture, and I'll use this as an example. One year, we talked about disclosure of ministerial facts. And I had a picture of, you might remember, I had a picture of a coqui frog and then a picture of a rooster on a signpost. And that was one of the items to kind of drive home the point. What is this? And do you have to disclose it? And does it make a difference where you are, where these animals were, et cetera? And we would talk, gosh, for 10, 15 minutes. And it would basically invariably bring up other scenarios, et cetera. And so I'm thinking, because I'm putting together the PowerPoint now as part of the final submission, that is one of the ways that we'll try to address that, by actually having examples of signs. I think we have business cards as examples, advertising, et cetera, to show so that the people who really are visual learners as opposed to readers can really drive home that distinction. The other point that I wanted to make, and I know we want to move the meeting along, is, every instructor is a little bit different. And so one of the things that we can do as a commission and as a staff is provide the foundation. But we really do rely on the instructors to a certain extent to come up with the war stories, to come up with the examples, et cetera, because it's a little bit different based on their experience. It's a little bit different island by island. And so that also, I think, helps to kind of make it real for folks. And then the last thing I want to mention is that this course, more than any other course that I've done, really is the product of staff input. We had a really, really good session because staff sees the things and fields the calls where people call in and say, "Is this right? Isn't this a violation? Can I do this?" etc. Nobody knows. It is more on the front lines of the staff work, and they contributed heavily to all of those examples and scenarios and things that you see in the manual. So big, big shout out to staff for helping out on that. Also to the ACE committee as usual. And I'll definitely look to have more pictures and diagrams and things in the PowerPoint as I put it together.
And thank you, staff, too, because this really is a really great course.
I know it's long overdue. It's been on the agenda for years. So thank you very much. But other comments, concerns, questions, commissioners, staff? Or Mr. Kaneshige before we... if not, he's doing a good job, but I do need a motion to keep this moving, I guess. Yeah. Just that what you read in here so far is acceptable and he's on the right track, and to keep going. He'll take your comments into account, but I do need a motion.
Move to approve the continuing education core A class.
Thank you.
Second.
It's been moved by Commissioner Acosta, seconded by Commissioner Emery to approve the core class thus far as drafted, and keep doing good work. Commissioners, all those in favor say aye. Aye. Any opposed? Not seeing or hearing any, motion passes. Thank you very much. This item is 4C1C. Application, continuing education provider, Hawaii Real Estate Licensed School, HRELS LLC, Administrator Ben Eager, and he is not here. Commissioners, you all had a chance to review this application. This is for continuing ed provider. Anyone have any questions for staff? Yes.
I wanted to find out, please, how many years has Mr. Igor been licensed? I know he's a principal broker, but I was just wondering that because our providers should be well-versed on both sides. So is it-
I don't know the exact date that he received his broker's license. He does, however, Hawaii Real Estate License School is a pre-licensed school currently. And now he's coming and asking to become a provider.
Okay, I appreciate that. There is a bond in here, but it's dated to 2023. Is it still active?
Yes.
It is, okay. Thank you. The signatures look different from one page to the next, but sometimes people do sign differently. Okay, Lenny, but just to check all this stuff out.
It's him, Commissioner Acosta.
Okay, thank you. Appreciate it very much. Those are my questions. Thank you, Jeff.
Thank you for your good eyes there. Anyone else have any questions, concerns? If not, I do need a motion.
I move to approve.
Second.
Been moved by Commissioner Abe, seconded by Commissioner Center to approve the application for continuing ed provider, Hawaii Real Estate License School. Commissioners, all those in favor, say aye.
Aye.
Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Thank you very much. Next item, 4C1D, course purchase contract. Best practices and understanding the essential contingencies to service your client. Author Oder Van Eager, provider Hawaii Real Estate License School, course category contracts, clock hours 3. So in this particular case, you have a course in front of you from the provider we just discussed. Anyone have any questions, concerns? Not?
Move to approve.
Second.
It's been moved by Commissioner Kyono, seconded by Commissioner Acosta to approve the application for this continuing education course purchase contract, best practices, and understanding the essential contingencies to service your clients. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Congratulations. Thank you very much. Item 4C1E, here we have another course application, condo lending, what agents should know. Author Dana Booth, provider Performance School of Real Estate, course category finance, clock hours 3.
So, Commissioners, this course came before you last month, and staff as well as commission noted some changes that they wanted to be made to the course, and they have made the changes, working with staff, and it's coming back to you for approval.
Thanks for the reminder. I was thinking it looks familiar, but it came in front of us. We did ask that staff follow up for them to make some changes, which they have agreed to and have done. Just to refresh everybody's memory. Anybody have any questions? Commissioner Acosta.
Thank you, Chair. I noticed that on number 8, and it asked for an explanation, but there isn't any. And then also number 9, the sentence was cut off.
Do that, Commissioner. We can ask them to go ahead and fill those in.
Please, yeah, the explanations. Thank you.
And finish the sentence.
Yeah. And then I also noticed that where they talked about USDA, we did mention last time about the Hawaii funding organization that we have there, and it's not on here. We talked about the USDA, so they added that, but the Hawaiian Housing Financing Corp, they didn't put anything in here about that. I know they're from Arizona, so they aren't aware probably of that, so that might be something that should be addressed in a class if we're talking about financing. It's not used often, but it is available. So, thank you.
Addition of HHFDC information.
Thank you so much.
Thank you.
Can staff work on this without coming back and talk about the next agenda and maybe just, yeah. So that we don't have to, so. Yeah, very good. Anyone else have any questions? Corrections?
Oh, so we approved the course subject to the full completion of the application as well as adding information on HHS-CDA financing programs.
Second?
Been moved by Commissioner Center to make the appropriate changes and work with staff, and seconded by Commissioner LaCosta. Commissioners, all those in favor, say aye.
Aye.
Any opposed? Any abstentions? Seeing or hearing any, motion passes. Thank you very much. Next item, 4C2. I am going to group again A, B, and C all together because this is for the examinations. And again, staff has been wonderful in providing to you all of the statistics of the people who are taking the exams and how they're doing. I noticed no major warnings, no minor warnings. People are getting compliant. Thank you very much, staff. Anyone have any questions or concerns? No, this is just a FYI, okay? Thank you. Moving on to item number 5, licensing and registration ratification. You have a list of approved applications for real estate dated May 30th, 2025. Any questions on that list? Any concerns? If not, do I have a motion?
Move to approve the applications for real estate commission as noted.
I'll second.
It's been moved by Commissioner Acosta, seconded by Commissioner Abe to approve the applications for real estate licenses on the commission dated May 30th, 2025. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Thank you. Item 6, licensing applications. We are going to move into executive session to address all licensing applications. Can I have a motion? I'm going to move to go into executive session. Can I have a second, please?
Second.
It's been moved by Chair Yamane, seconded by Commissioner Acosta to move into executive session. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Thank you. We're now going to Okay, we're back in regular session. We are on 6A, licensing application, Justine Pantojan. Commissioners, motion.
To approve.
Second.
It's been moved by Commissioner Center, seconded by Commissioner Acosta to approve the license application for Justine Pantojan. Commissioners, all those in favor, say aye.
Aye.
Any opposed? Any abstentions? Not hearing or seeing any? Motion passes. Congratulations, Ms. Pantojan. We are on item number 7. I am going to take it a little out of order since we do have people in the audience that need to make an oral statement. I will move them up to number 1. We do need to go into chapter 91 recess for this, okay?
But
wait. No.
if you're gonna take 7D out of order,
Yeah.
to hear oral argument, then
You gotta hear that now.
we will still be in open.
We're still gonna go chapter 91.
Still
but,
chapter 91.
For the purposes of the broadcast.
So we are in.
Gotcha. So I should tell them to keep it light.
Just to-
Yes. This thing, guys. Let's go.
Okay, thank you, Ms. Corby. You're on speakerphone in the conference room with the Real Estate Commission and the commission members and staff, just to let you know.
All right.
Okay. We are in Chapter 91 recess to discuss in the matter of real estate broker license of Iridescent Productions, doing business as Turquoise Hawaii Real Estate, and Rebecca Corby, doing business as Rebecca Corby. That's why we're here for, and thank you for.
Yeah.
Okay, very good. We're all at the same place. But I am going to give, who goes first? Who goes first?
Okay. Yes, hello, everybody. Thank you for your time and meeting with me today over the phone.
Oh,
Hang on one second. Hang on one second.
Oh, okay.
All right, we filed the exceptions.
So
So they go first.
Yeah.
No, I'm sorry, I didn't. So because the exceptions were filed by the other party, Ms. Corby,
Okay,
they are going to go first, okay?
okay.
And I'm going to have him introduce himself so he doesn't, I don't mistake his name again. Sorry.
Good morning, Seth Corbizan on behalf of the Regulated Industries Complaints Office.
Thank you, Seth. So, 5 minutes, I know it's tough, but if you don't mind, yeah, go ahead. Go ahead.
All right, Chair Yamane, Vice Chair Center, and esteemed members of the Real Estate Commission. Petitioner stands on his written exceptions and offers supplemental comments. Most consumers will never spend more money than on the day they purchase their home. They rely on the knowledge, expertise, and diligence of real estate licensees to guide them in understanding the condition of the properties they seek to purchase and to advise them on how to prepare and maintain properties that are going to be listed for sale or managed as rental properties. An unpermitted addition, modifications or repairs that are not up to code, and the dangers of unlicensed electrical and plumbing work are a few of the hazards buyers, sellers, owners, and renters are regularly exposed to. Real estate licensees are prolific users of licensed contractors and unlicensed handymen. Understanding the difference between the two, knowing when using either is appropriate, and faithfully adhering to the licensing statutes and rules falls well within the Commission's mandate to all real estate licensees set forth in Hawaii Administrative Rules, Section 16-99-3, subsection B, to endeavor to eliminate any practices in the community which could be damaging to the public or to the dignity and integrity of the real estate profession. By her own statement, through the sold listings by agent table from Hawaii Information Systems included with her letter in support, Respondent Corby leaves little doubt that she is very active in the practice of real estate, with lister side sales of $4,502,100 and buyer side sales of $11,079,220. The Commission should correct the deficiencies in the findings of fact and conclude that Respondent Iridescent Productions, LLC, and Respondent Corby aided and abetted pursuant to HRS Section 436B19, subsection 6, and employed or utilized pursuant to HRS Section 436B19, subsection 16. Rafael Garcia and his company, A Plus Handyman Yard Services, LLC, for 2 violations each, or 4 violations total, and violated HRS Section 436B19, subsection 17 as a consequence, prohibiting violations of Chapter 436B HRS once. So 5 violations total. The petitioner is not asking for the maximum fine possible under the statutes and is not suggesting suspension or revocation of Respondent Corby's license. However, Respondent Corby's admitted lack of knowledge that all real estate brokers, especially principal brokers, ought to possess, should be the subject of remedial discipline by the Commission. Require Respondent Corby to take additional continuing education of the Commission's choice and discretion, and we're suggesting that a limitation be imposed on Respondent Corby's license, prohibiting her from serving as a principal broker for a period of not less than 1 year, subject to Respondent Corby requesting removal of the limitation in writing after completing the additional continuing education. I reserve the balance of my time for rebuttal and to address questions from the Commission. Thank you.
If there's any questions? Ms. Corby, would you like to respond to that?
Yes, I would. Thank you. And I wanted to ask a couple questions. Does the Commission have in front of them 2 documents, Mr. Ota's recommended decision and then my response to that and support with exceptions?
Yes.
We do. Yes.
Okay, great. And has everyone on the Commission had a chance to read those 2 documents?
Yes, we have.
Okay. Okay, wonderful. So I just wanted to reference those again and restate my point again that I do agree and recommend Mr. Ota's decision, with the only exception being that I'm requesting the fine to be 2 $100 fines totaling $200. That's based on several mitigating circumstances. One being that I've never had any complaints or violations before. At the time that this occurred, I was a brand new broker, just about a month into having a broker's license. I did not knowingly violate anything. It was negligence. At the time that I hired this handyman, I was under the impression he was allowed to do the work that I hired him to do based on the handyman exemption. That's where the discrepancy was. And so he ended up charging me too much. I now understand the handymans cannot charge more than $1,500. I also want to point out again that I've already been punished by this whole incident. I've lost over $4,000 by this handyman scamming me. I am the one that brought this to RICO to their attention, and this particular handyman, Mr. Garcia, had actually done this to people before. I understand they went after him, but then I was very surprised and hurt and confused that RICO was also coming after me and accusing me of aiding and abetting. There's no way I aided and abetted. In order to aid and abet, the person has to know and have malicious intent that they're going to commit a crime together. And in general, the victim of the crime cannot aid and abet. So in this case, I was the victim of the crime. However, I do admit that I was negligent or I was ignorant of the exact details of the handyman exemption. I now know them clearly. At the time, I did not know all of the details of the handyman exemption. I do apologize about that. I also want to point out some other circumstances again that I did not refer this handyman to any clients. He worked for me, for only me on my personal property that I own. My LLC is a single member LLC, so it's just me. I only hired him to work on my property. I did not refer him to anybody. I did not help him with his enterprise to scam people or scam me. What else do I want to mention about that? Yeah, and I've learned my lesson. I've lost over $4,000 that I'm never going to get back from him. Furthermore, I've had extreme financial hardship the past few years, but especially the past year has been incredibly difficult. So Mr. Corpuzlan's recommendation to fine me thousands of dollars and suspend my license would be devastating. Working as a real estate broker is my only source of income right now. So taking that away for any period of time would be devastating. I would lose my income. I would most likely end up homeless and lose my house. Due to the financial hardship, I've already had to just get a mortgage forbearance. I'm finally getting back on track. So I'm actually in the process of making what's called trial payments for my home so that I can keep my home. And so it's a very crucial time. So if I were to lose my income and miss making these trial payments, they will move to foreclosure and I could lose my home and end up homeless. So I think that Mr. Capuzlan's recommendations are over the top and very cruel given all these circumstances. And I think a more appropriate course of action would be to find me a reasonable fine that I could afford. And given all these circumstances, I think that the two fines totaling $200 is reasonable, and I could afford that at this time. So that is my request to the commission. I do appreciate being part of this process. I've never ever gone through this before, so it's been very eye-opening. I 100% respect the profession and the importance of us upholding our duties. I absolutely take this seriously, that I have a broker's license and I have a duty to stay informed on these things, and I do. To that end as well, I wanted to point out all of the times I have reached out. You can look through the emails, but there's been several times I've reached out directly to the Real Estate Commission to get clarity around issues, around what I can and cannot do as a licensee, as well as clarify issues that other brokers and other licensees have done. So I do have a reputation of caring very much about this profession and very much care about protecting the public, which is, ironically, the whole reason I contacted RICO in the first place is because I knew I lost money and I got scammed by this guy. I learned my lesson, but I didn't want him to keep doing this to other people. And that's primarily why I contacted RICO, because I knew he was going to keep doing this. So I absolutely care about the profession and protecting the public. And with that, I'll finish my statement. Thank you so much.
Thank you. Commissioners, any questions to address Ms. Corby? But I wanted to see if you had any questions for her, but if not, another. No questions?
Actually,
You have a
just
question? Yes.
Thank you. This is Commissioner LaCosta. Ms. Corby, thank you for being on the call. So you said that you just had your license about a month when you hired the handyman?
That's correct, yes. This occurred back in 2022, so over 3 years ago. I got my broker's license. I don't have the document in front of me, but if my memory is correct, I believe it was January of 2022. I received my broker's license after passing the exam. And then it was February, so January, February is when I hired this handyman. And anyways, I believe I answered your question, so I don't want to rattle on. Did that answer your question?
It did. It was just giving me some background about the $1,500 exemption. That's kind of one of the first things you learn about handyman, because there are a lot of people trying to take advantage. The other question I had is, you were quite successful, and congratulations on your sales for both sides of transactions. So I was a little bit mystified as to why you have an issue paying a fine when when that income was provided to you.
I'm sorry, which income are you referring to?
The sales and the buyer side and the seller side that you represented in the documents was, if I remember correctly, it was about $20 million. Am I confused?
Oh, that is over my entire career.
Okay.
I've been licensed as a realtor, not a broker, but before becoming a broker, I worked on Oahu dating back to 2004. I left Hawaii, I left the profession for a while, and then I moved back to Hawaii. So over my entire real estate career in Hawaii, which spans over 10 years, I've completed over 150 transactions, which totaled about $15 million in sales. That doesn't mean I've earned $15 million. So realtors often say, the sales number, those are the total of the houses, but we make a percentage of a commission. And as I mentioned, the financial hardship over the last few years, the market, due to the economy, first we got hit with COVID, the COVID-19 pandemic, and then we've just further had a downturn in our economy. So in the last few years, I've really had a struggle. I forgot to mention also my health issues, which also impact that. So I deal with chronic illness, and I included in the document one of my diagnoses, which is narcolepsy. Which is really just a smaller diagnosis of a bigger one called Lyme disease that I deal with. But anyways, in the most recent time, I've had severe financial hardship. So at this time, I could afford the $200 fine. I definitely could not afford anything close to $1,000 or more at this time. So to clarify, the document I included was to show how I've never had any complaints from any members of the public, and I've completed over 150 transactions. And to your point about not knowing about the $1,500 handyman exemption, so prior to becoming a broker, I had worked under, I believe, four other brokers. I never heard anybody talk about this $1,500 limit. What I heard people talk about, and my understanding was that when you pull a permit, that's the colloquial term people use, pull a permit. If you have to pull a permit for something, you need a contractor. So my understanding at the time was, if there's permits involved, like you're building an addition or you're building a brand new home, you got to hire a contractor. But if you don't need a permit for the work, you don't need a contractor. That was my understanding at that time. I now know that that's not correct. I've now been able to read in detail the law and understand it fully. But that was my understanding after working for 4 different brokers. So it does seem to be, there's kind of some common misconceptions I've learned out of this whole thing.
Corby, I'm gonna cut.
I think this could also be a point of education.
Ms. Corby.
Corby, your time is up, so thank you.
Ms. Corby,
Okay.
thank you so much.
Yeah.
Sorry, Chair, I didn't mean to interrupt, but I just wanted to let you know, thank you very much for that. And we are practitioners that sit around this table, so we do understand both sides of that. Thank you so much.
Okay, thank you.
Any other commissioners have any questions for her before I let Mr. Corporal?
No? Okay, in rebuttal, I would just like to address a couple of Ms. Corby's comments. For one, I'm going to restate, we are not seeking suspension here. We have never sought suspension, and we're not seeking suspension now. And I guess it's alarming that, having worked for under 4 brokers, her understanding of the handyman exemption is reduced to you only need to do it if you pull a permit. Not suspension, and really what we seek here is remedial education for Ms. Corby so that she can perform her duties as a principal broker. Very, very serious duties in terms of looking after the interests of her clients. And you know, to that end, petitioner is advocating that, you know, she be under supervision for a year, so that she can so she can get the experience that she needs so that this doesn't happen again. And lastly, you know, this is addressed in greater detail in our exceptions. The state of mind requirement that Ms. Corby is advocating for, and indeed the recommended order is advocating for, is out of line with you know, prior decisions by the commission, as well as settlement agreements that, admittedly, not presidential, but they're certainly persuasive as to what the commission thinks constitutes aiding and abetting. And over again, you know, this precise situation has come up where a broker or a real estate salesperson is hired, an unlicensed contractor, and, you know, honestly, most of the time they settle. There's not a whole lot of case law about this because most of the time it settles. So, but that didn't happen this time. So with that in mind, you know, I urge the commission to adopt the position advocated by the petitioner in its exceptions. Thank you.
Thank you. Commissioners, do you have any questions, commissioners?
I had a question. Sorry, it's a little fuzzy.
Corby, I need to hold you off.
I'm allowed to
Ms.
ask
Corby.
a question.
Not right now. Not right now. I'm asking the commissioners if they have any questions.
Oh, okay. Okay, got it.
So basically, if you, just so that there's no misunderstanding, the final order in front of us is basically what we're supposed to move on. Is that correct? So it's just a matter of if we move to accept or reject. Is that moving to executive?
No. So we'll go into deliberation now. So if we could just excuse everybody and then the board can deliberate.
Absolutely. So we're gonna move to deliberate this, so if I can ask everyone to leave the room, and that includes Ms. Corby at the present time.
Okay, do you want me to end the call and you folks are gonna call me back, or I'll be notified some other way of the decision?
You'll get notified by staff.
Okay, so is this the end of the call for me?
Yes, correct.
Okay. Okay, thank you so much again for considering my position. I really
Thank you.
appreciate it.
Thank you.
Okay, aloha.
courtesy thing, maybe, to just let her know, like, that it's over if she's expecting.
Do you hear that?
Can we get her back?
Where's Rita?
Wait.
Did,
354.
Don't read it out loud.
Seth,
302.
Read it out loud.
You're being broadcasted.
Does it end in 03? Yep, thank you. Got it.
Oh, I guess he left.
Yes, they left.
Hey, this is Rebecca.
Rebecca, it's the Real Estate Commission calling you back for Chapter 91, but we did come to a decision. So the commission's final order was accepted the way you see it. Okay?
Hearings officer.
The hearing officers.
Sorry about, the last sentence you said got cut out, and sorry, I have it on speaker because I'm driving right now.
Yeah, so the hearings officer's final order was accepted.
As is.
Okay, the hearing officer's final order was accepted, so that means, what does that mean then? What is the final decision?
It's the 400.
The $400.
A $400 fine?
Correct.
Okay.
Okay.
Okay, thank you.
Thank you.
Will I be sent, some paperwork so I know how to pay that and so forth?
Yeah, she'll get
Yes.
the commission's final order.
You will get it from staff. Yes. Yes. Thank you.
Okay, thank you.
Okay.
All right, aloha.
Aloha. So we are, he's not there. Back in regular session? And I believe we addressed everything.
Do we?
We're in regular, that was an open session, we told her.
Just want to make sure that.
They're good.
Okay.
So we're back in regular session. All of the agenda items were completed. Our next meeting is scheduled for Friday, June 27th, 9 a.m. Same room. There's no other questions. Time now is 11:17 a.m. and the meeting is adjourned.